Last lesson we covered the background to the International Criminal Court, and today's lesson is going to cover the aims and effectiveness of the International Criminal Court. So let's get right into it. On paper, the aims of the International Criminal Court are really noble. The first aim of the ICC is to operate as a court of last resort to ensure those who commit the most heinous of crimes receive punishment. The second aim of the court is to deter people from committing mass atrocity crimes like genocide or war crimes by making it clear that no matter who or where you are, you will be held to account for your actions. In turn, the idea is that this will prevent crimes of mass atrocity occurring in the first place. The third aim of the court is to actually assist states to build up and strengthen their own judiciaries and in turn bolster that state's own ability to carry out justice at home. So that's that. We have a global rule of law, a court that's able to indict and prosecute those responsible for the gravest crimes across the world, deter people from committing further atrocities, and to build up the courts of states across the world so the justice can occur back at home. Great, I think we're done here. Roll the world peace video clip, everybody. Yes, unfortunately for the ICC, since its establishment, it's had a really hard time establishing its authority and demonstrating its legitimacy. Now, with the ICC, these difficulties come from all different directions. First, major powers like Russia and China, unsurprisingly, I guess, given their track record of the rule of law in their countries, have refused to sign up to the Rome Statute, meaning that they're not actually under its jurisdiction. But somewhat more surprisingly, the United States, that leviathan of liberal values, has also refused to sign up to the Rome Statute, meaning it can't be prosecuted or investigated by the ICC either. Now, to be effective, the rule of law has to be seen applying to all members of a community, be they powerful or weak. Otherwise, there's just this perception that the rich and powerful can just operate with impunity while everyone else has to actually abide by the rules, which is quite unusual. Oh wait, no it's not. Second, it very often happens that states where individuals under investigation by the court reside will do everything they can to actually make the prosecutor's life more difficult. By covering up evidence, refusing the prosecutor access to the country itself, intimidating witnesses, and refusing to detain those accused. This in turn affects the prosecuting ability of the court. Indeed, since it started operating, the ICC has publicly indicted 41 individuals. Now, of these indictments, 24 of them are actually proceeding. And of the 17 against whom the proceedings have actually been completed, 1 was acquitted, 1 had his case declared inadmissible, 2 had charges against them withdrawn, 6 had the charges dismissed, 4 actually just died. What's that? Carry the 1. 3 convictions. 3?
Balls.
Yes, 3. I mean, it took the court 6 years and somewhere in the range of $500 million in legal costs to secure its first conviction in 2015 against a Congolese warlord known as Thomas Lubanga, who was found guilty of recruiting child soldiers and using them in conflicts across the Congo. Now, perhaps it is unfair to expect the International Criminal Court to be relentlessly prosecuting those who commit mass atrocity crimes, given that it's constantly being undermined, underfunded, and ignored by those who have set it up. But it also means that the ICC has not lived up to those idealistic dreams of those who founded it of prosecuting those who commit the worst crimes imaginable and deterring others from doing so. I mean, it didn't cause Syria's president Bashar al-Assad to think twice before unleashing a campaign of devastating bombing against his own citizens, killing thousands of people. And notwithstanding some change in government in Syria, al-Assad's unlikely to face the International Criminal Court because Syria won't refer him because he's the president of that country. And second, the UN Security Council can't refer him because his good old mate Russia will just veto that resolution. Just like someone vetoed his chin. And there's these deeper questions when it comes to the ICC. Are the people in whose names they're acting feeling a sense of justice? In the Lubanga case, for example, charges for mass rape were actually dropped in order to ensure a speedy prosecution, meaning that the political need for the ICC to actually demonstrate its effectiveness by getting a conviction at all may have actually weakened the sense of justice that was felt by his victims. Ultimately, the International Criminal Court has been this grand experiment in trying to extend the rule of law globally. But despite its noble intentions, the court has actually faced a huge amount of challenges. And now to top it all off, we're seeing this inverse of what we saw in the 1990s with the rise of populist governments, politicians, and movements who are deeply skeptical of any body that terms itself a global institution. And so it seems that the ICC, battered as it already is yet to actually face its worst headwinds. The best case scenario for the ICC is it manages to keep itself relevant and drift on through these headwinds. Worst case, it becomes a textbook example of something emerging from a boom in political good vibrations before being neglected and cast aside into obscurity. Just like Daniel Bedingfield.